Just as one deal. But then I texted him last night, a picture of a mug with the snow and then he said, what are you doing? I told him, he said, oh, so you get to know Adler again.
I don't necessarily need to see her. I just want to.
All right. Please be seated. All right. The Court of Claims of the State of Michigan is now in session. This matter of Eric L. Vandussen versus Dana Nessel in her official capacity as the Attorney General of the United States. The Attorney General of the State of Michigan, this is case number 23-0077MZ. I'm Judge James Robert Redford. I'm the Court of Claims judge assigned to this case. Today is the time and date set by the court, January 21st, 2025 at 1:00 p.m. to hear counsel's oral argument on the defendant's motion for summary disposition. Court's reviewed the pleadings, had a chance to review other cases the court previously served in. It's my privilege to be here with everybody. If we could have counsel identify themselves, that would be most helpful.
Please, court, Reverend Vandussen, Nelson, attorney for the plaintiff, Eric L. Vandussen. Oh, okay.
Oh, right. Sorry. Thank you.
Sorry, Your Honor.
Yeah. And our court reporter today is Mr. Robert Trudell, and he is attending with us by Zoom. So we all, and I know it's an unnatural circumstance, and I'll try to catch myself from asking for responses from counsel when you're not standing at the podium. But there may come a time when both of you gentlemen will need to be standing next to each other and just moving one side to the other as we go back and forth on questions. Okay?
Absolutely, Your Honor. And again, good afternoon. Frederick Sig Nelson, attorney for plaintiff Eric L. Vandussen.
Thank you, Mr. Stieg Nelson.
Good afternoon, Your Honor. Assistant Attorney General Adam DeBear, appearing on behalf of defendant Dana Nessel.
All right, thank you. And I would note, because the court received at about 12, I didn't receive it, but our court's outstanding court staff received it at around 12:50 today, a media request from some media outlet. They wanted to get the Zoom connection. And I then said, well, we don't have a Zoom connection for this. So it's now being live streamed. So this hearing is being live streamed just for, I'm sure it won't make any difference to anything either counsel will say, and hopefully nothing the court would say, but I didn't want there to be any confusion. So as far as I understand, the live stream is up and running. Anyway, I have had the chance to review the pleadings. Mr. DeBear, I believe this is your motion. I'd be happy to. We're not taking any proofs today. Is that correct?
I'm not prepared to offer any proofs.
Okay. Yeah, and Mr. Stieg Nelson, you're not offering any proofs today, are you?
Thank you for asking. I do have one additional affidavit that I was going to request that the court consider additionally in lieu of any additional proofs. It does have an exhibit as well as contains an additional hyperlink to a short clip from what Mr. Vandussen filmed during the Antrim County trial. I've shared that with Mr. DeBear yesterday, but I believe it goes to the heart of the issue, specifically regarding the public domain issue that's being alleged, and I can file it after today's hearing if the court would look at it before ruling.
What's the people's position? This is where you get to stand next to each other, so why don't you both stay up there?
I take no position and leave it to the court's discretion. I'll state for the record, I haven't had the opportunity to review it, but as Mr. Stignilson says, it appears to be just information with respect to his client having previously videotaped the trial and overseeing the exhibits. So to the extent that that's the contents, there's nothing particularly surprising.
Okay. All right. I'll conditionally admit it. If it's, I'll give you, today is, Tuesday, January 21st. If between now, I'll give you, Mr. De Beer, until, 4:00 PM on Friday. Let me just check here. Just count. Too many screens. All right. Okay. So, no, that's February. No, not January. So Friday is, January 24th. So I'll give you until 4:00 PM, Friday, the 24th of January. If you want to interpose any objections to the court considering it, substantively, I may review it before then. I will do that which judges are instructed to at new judges school. I will disregard it if I determine later that it was inappropriate to consider. But does that sound satisfactory to you?
Yes, it does. Thank you, Your Honor.
Satisfactory to you, Mr. Stig-Nielsen?
Yes, thank you, Your Honor. I do have a hard copy if the court would like to.
You can provide it to the court security officer. My law clerk will take it. And all right. Okay. Thank you. All right. Then let's have the benefit of whatever comments you'd like to first share with the court, Mr. DeVere.
So there's a handful of sub-issues at issue in these motions, both the motion for the protective order and the motion for the for summary disposition. I plan on focusing my comments specifically on whether the particular records are exempt from disclosure, so the disclosure issues, but I'm happy to answer any other questions that the court may have.
Okay.
So
Good.
first of all, with respect to this lawsuit, there are two separate FOIA requests at issue. The first one dealing with the trial exhibits. The only exception or the exemption that I believe that the department raised with respect to the trial exhibits were exemptions to exclude the information of a personal nature that if disclosed would constitute a clearly unwarranted invasion of personal privacy. And we did that specifically to certain categories of information, as the court's aware, that are identified in the motion. Addresses, driver's license numbers, dates of birth, phone numbers, and Facebook identification numbers. The only category of those records that is not discussed in case law is the Facebook identification numbers. And I think the important thing to consider with those Facebook ID numbers is they are members of the public, i.e. citizens, non-government Facebook IDs. They are private Facebook profiles for the individuals who happened to be in posts or comments or messages amongst the various trial exhibits that were offered into evidence during, I believe this is the Jackson County trial case.
Mm-hmm.
So with that said, the department would submit that that falls within the definition set forth in Michigan Federation of Teachers for information of a personal nature. And I think it is clear that there is no manner of thinking in which those particular ID numbers could shed light on the inner workings of government. They are
How do
only.
There were exhibits admitted at the trial, right?
Correct.
And is the information which is being sought to be withheld under the personal information wheelhouse of bases to withhold under a Freedom of Information Act request, were those displayed publicly? And if they were publicly, meaning on the record in open court, and if they were, why does that exception to production still apply here?
Well, I'll start first with the court's question about the public domain kind of issue, and then move specifically to the Facebook identification numbers.
Thank you.
Whether the information was introduced during open court is not relevant at all to the consideration of 13(1) way, and the Supreme Court has told us as such in Michigan Federation of Teachers. Specifically, it says the mere fact that information has been disclosed or has been or is partially available in the public sphere. And I believe the citation, if Your Honor is pulling it up, is it's found at least in footnote 5 and page 12 of the department's brief, and the case is 481 Mitch.
Footnote 5, page 12.
Yeah, footnote 5, page 12. And again, the case citation is 481 Mich 657. And what the Supreme Court tells us there is the mere fact that information has been or is available in the public realm doesn't defeat the exemption under the FOIA. For example,
Does it make a difference in whether or not it's been admitted in open court?
no, and in fact, the Supreme Court's rules recently with respect to the filings of court documents prohibit the filing not of Facebook identification numbers, but of all the other categories of information that is at issue here.
So interesting that you bring that up, because I know I do want to speak with brother counsel on that, because just last week I serve on an advisory panel of sorts, and we talk frequently about public access to file pleadings and dockets and greater transparency and these types of things. And a subject at the meeting I was just in last week and then a meeting in October is how under PACER, the federal electronic filing system, there is a series of things that cannot be included in very much PII, personally identifiable information. And there's also, in addition to the processes and protocols of the federal judiciary, there's federal statutes on this. So what of any moment is all of that?
Well, I do think, without being familiar with those statutes myself, although I do understand the alerts that we get when we go to file things on PACER, we being attorneys.
Right. I was fortunately, while I was president of the Federal Bar Association in the Western District, when PACER was getting started, I was already elected to the bench, so I didn't have to deal with that in my practice. So I'm sure you young lawyers who have been doing it for 20 years plus, since I left the
Close to 10.
that's, yeah, so I left your side of the well 22 years ago. So anyway, okay.
But in any event, I think it's at least persuasive authority. And it's persuasive because the federal authorities, whether it be the courts or the administrative agencies involved, whoever it may be, they recognize that there is certain information that isn't relevant to an ongoing matter of public dispute. Take, for example, the home addresses of the individuals whose information appears in the trial court records. Whether someone lives at 12345 Main Street has nothing to do with the inner workings of government. And if the court, gives a close consideration to Michigan Federation of Teachers, it explains that with respect to the balancing part of the test, when the information doesn't shed light on the inner workings of government, it is sort of categorically falls within that exemption. And I would submit that.
No, I recently had the privilege of serving on a Court of Appeals panel that had the good fortune to address some of these questions. So it helped me prepare for today. So.
And with the non-Facebook ID numbers, I would submit that the court is bound by Michigan Federation of Teachers with respect to the certain categories of information. I believe it's home addresses and telephone numbers in there. And with
it include the names. The names are included, right?
We didn't exempt any names, with the exception of there may be one in the second case where a confidential informant's name was exempted, but no names were exempted in these trial court exhibits.
Opposing counsel talks about last time we had the chance to visit on these types of issues under not an identical case, but it was the same facts generally giving rise to it. You are
Yes.
familiar with those arguments he's discussed. And I think he's said either collateral estoppel, or I think that's what it argued. I read the brief again to this morning and I apologize. So he's saying, hey, listen, the judge decided this, you got to turn this stuff over. What do you make of that argument? Other than I recognize fully that a decision of a trial court, whether it's me or somebody else, is not binding authority.
Right. So with respect to collateral estoppel, it has zero applicability here,
Why do you
and
think
for
that?
several reasons.
Okay.
First, Your Honor, these are different FOIA requests and actually different issues. If the court recalls the previous issue, the department had taken sort of a broader stance with respect to the exemptions because there were still ongoing
Right.
criminal procedures at that point in time.
I actually reread my previous opinion in order today, thanks to a great lawyer who helped me find it. And so I had the chance to revisit that. And what do you think the court's ruling was based on in that case?
From
Other than a mistake of law, obviously.
Well, I think that from my perspective, Your Honor, my memory of the court's opinion is that it was addressing the department's then position that it could exempt from disclosure records that were admitted in open court because it had the potential of disrupting ongoing criminal proceedings, which was the exemption that fell under. Was MCL 15-243-1B, the sort of the law enforcement exemptions method. There was an order in the opinion that did direct the department to produce the records in the manner that they were admitted at trial, but the reasoning of the opinion was centered on 13-1B.
And the privacy portion that exempts is 243 what?
243-1A, Your Honor.
Thank you.
And again, the Rataj versus City of Romulus, 306 Mishap 735, as well as the Michigan Federation of Teachers case that we've discussed. The department binds the court with respect to the categories of information that are referenced in those cases. The only piece of information that isn't subject to any binding state court opinion are those Facebook identification numbers. But again, the reasoning.
Do I need to have more evidence on what those are?
No, I think it's explained in the papers what they are. Every Facebook account has a number that's attached to it. So John Doe could open up a Facebook account and it would produce an ID number for the account. And you can search that ID number in the account, the ID number, you can search it in Facebook and pull up John Doe's account. That's what a Facebook ID is.
Let me ask you, I had a Facebook account in 2014 when I ran for a certain office that the people who were helping me said, you got to have a Facebook. So we got one together. It has continued until pretty recently, actually. There were administrators. I wouldn't know how to put something on a Facebook page if my life depended on it. My spouse is very conversant in it. But tell me what is the mechanism as you understand it? If you have this Facebook ID number, and do you have to be a Facebook participant to be able to enter it in, or?
The public can type in, like any person, whether they have a Facebook account or not, is able to go into facebook.com and search information. Certain people may make their profiles private. Certain people may make theirs public. I like Your Honor, I'm unfamiliar, taking your Facebook example with Twitter, X, Instagram, TikTok, unfamiliar with that. And I think there's more restrictions on the different social media applications with respect to who can access those applications. But with Facebook, the last I checked, anyone, even if you're not logged in on the computer, can type in an ID number. And the department didn't take a separate step of determining which of those individual users said that their account information is private and which said, they were public. They didn't go to determine whether those people actively maintain those accounts. It's just information that relates to a person's Facebook account, which has nothing to do with the inner workings of government. Those Facebook ID numbers were not involved in any prosecutorial decisions. They were not involved in any particular questions of material fact that were relevant for the criminal courts to decide. They were merely numbers that happened to be on printouts from subpoenaed Facebook records, the majority of which is not redacted. So for example, and I believe these exhibits are at least partially attached to the department's reply brief because we wanted to give the court an idea of what Mr. Vandussen received. The only thing that's redacted from those Facebook records are that 8, 9, 10-digit ID number. Everything else, all the content, all the information, all the names are present with the exception of that number. And there's certain records that will have phone numbers associated with the account. We redacted those phone numbers, but again,
Okay.
that I would submit falls within Michigan Federation of Teachers and Rataj quite clearly.
What do you think if you and I and opposing counsel were, instead of in a courtroom and litigating this, if we were all getting a cup of coffee and if I said, hey, what's going on? You know, and you two guys said, you two gentlemen said, I should not use the word guys because I suggested to some attorneys recently, they shouldn't say that. So you two gentlemen are there. I happen to walk up, I get a coffee and sit down with you. Hey, what's going on? Oh, well, we have a case against each other. And what, if you were to explain to me what you agree on and what you disagree on, what would you say is still in dispute between you and the plaintiff in this case?
Well, I think with respect to the first part of the lawsuit dealing with those trial exhibits, it's just the information that we've exempted from disclosure. The addresses, the phone numbers, the dates of birth, the Facebook ID numbers. They have received, I say they, the plaintiff has received all the other information that was introduced. I believe these were trial exhibits as opposed to prelim exam exhibits.
I think that's right.
But they, in any event, they were court exhibits and plaintiff has received every single one of those exhibits. The only information that he hasn't received, we've discussed. And I think the important thing to kind of keep in mind from a practical perspective is for members of the public whose information is in the various governmental public bodies, you know, that are under the FOIA, I would submit that the public would not feel too happily about the department just giving all of their information out to anybody who requested under the FOIA when there is an exemption at the departments and all the public bodies avail, which is MCL 15243-1A, which allows them to not produce, to withhold information of a personal nature. Because this information, there is simply no credible argument that it could, the home address in and of itself, the Facebook ID in and of itself, could shed light on the inner workings of government. None. And for that reason, the Facebook ID numbers, as well as all the other, clearly meet the test established by Rataj and Michigan Federation of Teachers.
When were the documents which were produced, do you understand that, is there any dispute that they were, whatever you did produce, is it your position that it was produced timely or that it wasn't produced timely? My understanding is Mr. Vandussen was pro se at the beginning of this process, that in some response proffered by your office, I'm going to paraphrase it, okay? I know it's not the exact words that were used by much more capable counsel than me, but something along the lines of, here's our initial response. We're reviewing or likely to supplement it. By the way, if you hire an attorney, you're not going to be entitled to attorney's fees because we're going to give it to you anyway. It's not going to be the actions of your lawyer, which led to the production. Is that a fair, a very rough and not, verbatim?
Yes, you're reciting the department's affirmative defense number. I can't remember, but it's in
14
our,
or something like that.
right,
Yeah.
it's in our answer. And I was the signatory to that answer, so I do remember it well. And the records were not produced at the, if you have an administrative level and a trial level, they were not produced at the administrative level. They were produced at the trial court level. And in our earliest response, we did indicate that we would be making a supplemental production because intervening in the interim of the first denial of the trial exhibits FOIA request and the lawsuit, or at least the answer was this court's opinion in what I'll call Vandussen 1, right? Where this court said
Okay.
we had to produce everything in the manner. So that changed. We weren't going to make any other related objections due to future criminal procedures. We were just going to stick clear to 243-1A, and that required, unfortunately, a painstaking review of all the trial exhibits to single out which of, phone numbers, home addresses, Facebook ID numbers, et cetera.
Why wouldn't those have been precluded from the petite jury in the first place?
They may need to be precluded now. I've done more federal court trials than I have state court trials. But my understanding with state court trials is that the parties aren't generally filing their exhibits with the clerk of the court. They're just offering them to essentially the judge presiding over the hearing, and they're considered by the jury, et cetera. But court records, you have to exclude those from now on. And I'm not entirely sure, as I stand here today, whether you would need to do the same thing in an actual trial where you're not filing the records with.
No, I will confess, when I was a lawyer for 17 years, when I was elected in 2002, and I began trying cases in the 17th Circuit in 2003. And I think I had 34 trials, jury trials that first year. And I remember at the end of probably the first trial, there was a criminal matter, and okay, well, where do we keep the exhibits? And my staff said, we don't keep the exhibits. I'm like, what are you talking about? It's gotta be, it's part of the court file. And they, oh, no. Parties keep the exhibits. I go, well, what about appellate review? And the lawyer said, or my staff told me, no, the parties, that's their responsibility. And that was very different from my experience as a federal litigator. It's like, wow, okay, that's really different. But yeah, so I hear you on that. And along those lines, is it of any moment about Ms. Hackman Clark's affidavit of April 16th, 2024, paragraph, I think 10. Yeah, 10, where she indicates court didn't keep the exhibits. Should that weigh into this court's determinations as far as the necessity to disclose and provide the unredacted exhibits?
I think perhaps there's an argument that it's persuasive and it helps the department's case because they were never officially filed with the court. That said, I think it's irrelevant because under Michigan Federation of Teachers, the only considerations are the elements of the exemption, 13-1A, the personal privacy exemption. Is it information of a personal nature? Yes. If disclosed, would it constitute a clearly unwarranted invasion of personal privacy? The answer is yes, because it has nothing to do.
Right, but that second part of the test, would it be a clearly unwarranted invasion of the individual's privacy? In Michigan Federation of Teachers, were we talking about admitted exhibits in open court?
We were not, but as is noted in the footnote of our brief, the availability of that information does not render void the potential availment of that exemption. And there's actually a corresponding federal case where the public domain exemption is more, it's actually discussed in cases. I think it's exemption 7C in the federal FOIA. The same thing, the fact that this information of people's personal information is disclosed in the public realm doesn't defeat it in federal court either. And I think
you cited that the federal cases, and obviously there's a body of Michigan law which talks about us considering federal cases in this matter for the same reasons we talked about the last time we were together in Vandussen 1.
right.
So-
I will note that, as an example, if, it is an individual attorney general who is disclosing their own personal information and an individual attorney general is subsequently sued. And then there's the argument of, well, well, this individual attorney general introduced this information. That could be a question, but this isn't Dana Nessel's information. This is information from not only the criminal defendants, some who were acquitted, some who were convicted, but everyone's sort of involved with that scheme. This is private citizens unrelated to government, and the actions of a public body in a trial court cannot, I would submit as a matter of law, impact the privacy rights and privacy interests that members of the public have. Just sort of a matter of course.
Okay.
Moving on to the second lawsuit, there are sorry, not the second lawsuit, the second half of the second lawsuit, right? So the second FOIA request.
Yeah. So is it Vandussen 2A and 2B or?
Yeah.
So,
I think this could be Vandussen 2B.
okay, and Vandussen 2B. What would you like to hear from?
In
the advice of the court?
Vandussen 2B, I think our motion papers set forth the arguments well. I just want to highlight for consideration that accompanied with Danielle Hageman Clark's declaration is the exemption log that was.
I'm glad you brought that up. I have a couple of questions about that. In the exhibits that followed the affiant's declaration, there's one that's 40 pages long, and that is described as an exemption log. And then exhibit F is described as a privilege log. What's the difference?
Well, I think, to be honest, they both mean the same thing, but I think privilege log is general litigation and exemption log would be more specific to FOIA. In the federal FOIA, they have the Vaughn Index, which is named after a federal court case that discusses those things.
Just so long as it's not the Redford Index.
Right,
So
right.
maybe it'll be the Vandussen Index for our next one. So Mr.
Exactly.
Vandussen.
But no, it's an exemption log of the list of the various exemptions. So it's essentially the same thing, but.
Okay, so when I look at the page 1 through 40,
Right.
all right, and we've got these entries, and is this was this provided to opposing counsel?
That was provided to opposing counsel. It was not originally provided to plaintiff at the administrative phase. The privilege log, which is exhibit F, is what the department produced at the administrative level.
Oh, okay, so that was before the suit was filed,
Correct.
exhibit F was provided.
If I'm remembering my letters, the shorter privilege log
Yep.
was produced before the lawsuit was filed. The longer 40-page one, that's titled the exemption log, and that is, I think, attachment 1 to Ms. Hageman Clark's
I
declaration.
think that's correct.
That's what was produced during litigation. And that was the
Other than the things that are memorialized in Ms. Hageman Clark's attachment 1, the attachment 1 to her affidavit, is attachment 1 the universe of documents that the Attorney General did not provide?
It is the universe of the documents that had either a partial exemption or were exempted in whole.
Okay, and so that leads me to another question. There was a letter, attachment 2, where Christy Wendling Richards, the FOIA coordinator, on May 5th, provides a 6-page letter to Mr. Vandussen and goes through, and says what she says. Is it the position of the Attorney General's office that when we consider the May 5th letter, that this is sort of is this the roadmap to, hey, we've complied with FOIA, if you will? We've either given it to you, or here's what these things don't exist. 2, 3, 4, 5, 8, 9, 10, 11, and 17 don't exist, so we can't produce it. We've already complied and given you the responses to 1, 6, 7, and 12. And the rest we think are exempt for the reasons we talked about in this. Is that?
Yes, at the administrative level, Your
Okay.
Honor, that is the official notice, the written notice, I think is the term that the statute uses, to the FOIA requester, Mr. Vandussen, regarding his request for records and whether the department possesses all of those records, and if so, whether certain records are exempt in whole or in part from disclosure under FOIA.
Okay, I keep interrupting you, I'm sorry. We were provided in the reply brief some 1,000 pages of exhibits. I will confess, the lawyers who helped me have reviewed those. I have not reviewed those 1,000 pages. I've reviewed a lot of other things in this case, but I haven't reviewed those. Has the Attorney General's office or the defense, or I'm sorry, or the plaintiff for that matter, made any submission to the court in Vandussen 2 that said, okay, Judge, we want you to look at these in camera? Has anybody given us anything along those lines in this case?
No, all that I can say is that in the department's brief, it's our submission for Vandussen 1. The court doesn't need to look at home addresses to determine whether
No,
they're
that's
exempt from.
Vandussen 2A.
Sorry, Vandussen 2A.
2A.
Thank you, Your Honor.
Yep.
Vandussen
Vandussen 1
right.
is
Is
done
done.
because you
It's
didn't
done.
appeal it, so.
We settled.
So that's-
But Vandussen 2A, there is no need, obviously, for the court to look at a home address and
Right,
in order to make the disclosure determination.
okay.
For Vandussen 2B, the department argued that because of Ms. Hageman Clark's declaration, along with the exemption log, which sufficiently set forth the bases for exemption, that we've satisfied our obligation under FOIA.
Okay,
And
I
that-
want to just make sure I haven't failed my responsibilities to review something in camera.
If the court.
No,
did-
I'm not
no,
asking
no.
for it, but you haven't provided anything and said, hey,
Correct.
Judge, look at these 1,000 pages in camera, and then you decide. I think you've said you're willing to let me do that if I
Correct.
decide I need to.
Right.
Okay, all right.
Department says the court doesn't need to, but obviously we'll provide them if the court determines otherwise.
Thank you. Okay, no, I just, that was good.
So those, that 40-page exemption log identifies approximately, going off of memory, 255 records. There's certain records that will have NA listed in there or produced. There's no need at all for the court to review those records because the plaintiff has already received those records. There are certain records, however, where there is a substantive response in the body of each one of the
No,
columns.
I've read the entirety of the exemption log as well as, frankly, I think the basis for the exemption. Not frankly, I've read the basis for exemption. I've read where there's obviously the author is frequently one person and then towards the later part, it becomes another person. No, this I
Right. And what the declaration does on top of that is simply offers 5 categories of essentially lumping each one of those approximately 250 records into 5 categories. And again, the 5 categories are internal memoranda, requests for sentencing, requests for plea authority
Right.
that we submit are clearly within work product. There's internal communications, which are kind of the same, except they're not memos, they're emails regarding updates with respect to the case, et cetera. Again, we would say that those are exempt under work product. And also just for to be clear, also under attorney-client privilege, because the department takes the position that we can advise the attorney general just the same as we can advise the director of the state police, the director of, Health and Human Services, et cetera. Draft documents, for example, if we have a witness list that is in draft form that we're getting ready to prepare for an upcoming trial, work product.
I'm curious, you don't need to talk a lot about it.
Okay.
I'm looking forward to opposing counsel's positions because I've read it with interest. I mean, I've told the lawyers before, I've had such great privilege to serve in a variety of different positions. I've been the recipient of advice. I've been the provider of advice. I've been the adjudicator of issues. Um, I've drafted privilege logs. I've represented lawyers in cases. I mean, this is yeah, we'll look forward to hearing what opposing counsel has to say.
Understood. Well, then with that, Your Honor, I'll sit down for the time
Okay,
being.
good. I'm sure we'll have more time to chat. So.
Good afternoon again, Your Honor.
Afternoon.
Frederick Signilson on behalf of Mr. Vandussen. Before I begin, are there any specific questions the court would like to?
Yeah, sort of
Dive
the,
into?
we meet in a coffee shop question. If the three of us, you two fine gentlemen are sitting there trying to work this out like good lawyers try to do. And I happen to walk up and I wasn't the assigned judge. Hey, how are you guys doing? What's up? How would you describe the situation?
As to what is still in dispute, I believe was specifically the
Mhm.
court's question. As to count one, I think really what is in dispute is whether or not the display of these exhibits in their unredacted format in the public court, both being broadcast on the internet, where Mr. Vandussen was able to film the exhibits, where anybody could have seen him, whether or not that the public domain exception overrides the privacy interest as pertains specifically to perhaps the more clear-cut areas like dates of birth, addresses. To dive into the Michigan, and this is maybe more than the coffee shop discussion, Michigan Federations of Teachers, I don't think it's as expansive as is being argued here and the way that we're looking at it, because that pertains specifically to government employees' addresses. We're talking here about, at this point, convicted felons' addresses.
Are 100% of them convicted?
The ones that, well, not, I believe the addresses that are redacted, the majority of the addresses that are redacted are Joseph Morrison and Pete Musico, who have both been convicted. And it's also
Yeah,
their
but they're
Facebook.
not government agents,
Correct.
either in the pejorative or the literal sense. They're not government employees. They're private citizens who have been charged by the charging authority. They have subsequently had due process and been convicted, and I'm guessing from the way I understand how calendars work, I assume they've probably been sentenced. Is that correct?
That's correct, Your Honor.
All right, and I'm assuming they're exercising their appellate rights at this point. Maybe they're not, maybe, but at any rate, why does the temporary display of that in the courtroom? This is not a law enforcement exception. This is the last time we were here in the first case, obviously the court speaks through its orders, and on the facts of that case, I concluded that the law enforcement exemption does not apply because it can't apply anymore to something that's already in the front focus. And I don't think, and obviously what I said in a previous court case is not binding even on me because I'm a trial judge. I have no, it can be persuasive. Certainly most judicial officers, I think, try to be consistent. But they're not saying that, hey, judge, law enforcement exemption, we don't have to provide this. It's obvious. They're saying, no, this is a privacy, it's subsection 1A. It's information of a personal nature. If public disclosure of the information would constitute a clearly unwarranted invasion of an individual's privacy.
Correct, Your Honor. And everything the court is saying is correct. And I would note that the privacy exemption was raised both in the government's brief and in Vandussen 1, as well as.
Yeah, but
as
if you remember, in my opinion, which I think is what's important for me, frankly, they may have raised it, but I didn't rely on that.
That's correct, Your Honor. That's correct.
So I read believe me, I read with interest my opinion. What did I say the last time? So, because believe it or not, there's been, let's see, 200 and, well, close to 300 Court of Appeals cases I've had the privilege of serving on since then, many court of claims. It's an opportunity of service each day. Had a lot of other cases. I didn't remember exactly what my holding was. So, one of our great lawyers found the opinion for me. I read it. Yeah, I mean, if I had said, hey, and this privacy thing is no good too, I think it's a different scenario. But I mean, obviously, what I said isn't relevant.
Correct,
It's
Your
what the
Honor.
law is, because as a trial judge, I don't pronounce what the law is. I follow the law. But
So I would submit, Your Honor, that the way that the court reached its holding in Michigan Federation of Teachers is looking at what kind of privacy right is associated with a home address, right? And talking in that case specifically about the employees of the University of Michigan. And they look to, and I don't know how to pronounce it, if it's Mager or Mager, but the case about the gun ownership. And where they looked at the gun ownership rights and sort of they talk about the Bradley test and they expand on it and look at the customs and mores and the ordinary community understandings of these things. And and really when you look at someone who's being charged criminally, someone who goes through a criminal trial, and whether or not they're convicted, if they're convicted, there's even additional opportunities for the government to display publicly those addresses. And when you
well, if they're convicted of certain offenses,
that's correct, and that leaves aside the whole issue of the Sex Offender Registration Act, for example. But on Otis, there's information on Otis that would not otherwise be available. And so
Like
what
what?
I'm
seriously, like what?
like dates of birth. Anybody can go on to the offender tracking information system and look up the date of birth.
It has
of
the DOB of the.
That's correct, Your Honor.
Convicted person.
That's correct. And so
I have looked at Otis. Because it doesn't have addresses, does it?
it does.
And Otis is, for purposes of the record, is the offender tracking information system, which is, I think, produced by the Michigan Department of Corrections.
That's correct,
I
Your Honor.
don't know that for sure, but that's what it's not the elevator company. Although if you Google it, you'll get the offender tracking and then you'll get the elevator company as well.
That's correct, Your Honor. And all this really is to say that there's a different treatment of these addresses than when we're looking at of just random employees at a business or at a university. And specifically, the Attorney General, when they prosecute someone, they file a complaint. And I understand that some information is redacted from the complaint, but what's not redacted is the person's address. Anybody can go into any court file in the state of Michigan and look at the address because it's the first thing that says under a person's name, people of the state of Michigan versus John Smith, and the address is below, and it's not redacted. And it's not redacted for these individuals that we're talking about right now, if you were to grab those court files. So it's a different class of addresses. And so that goes obviously to the first prong of what we're talking about. And I think it also sheds light on the second prong. And here, what we're dealing with is the government's prosecution of, it wasn't charged as a conspiracy, but for colloquial terms, it was a conspiracy, to do this act of terrorism, to kidnap the governor. It was people conspiring together to do this thing. It involves locations. It involves secret meetings. It involves meetings under,
Why does it matter? Okay, yes, of course it involves meetings. You have to have either a specific agreement or an implied agreement where there's a meeting of the minds. But so what, as far as the home address of a person?
because
That's not in the court record from this document.
Because a person who is trying to assess what the government did when they're looking at the entire prosecution as a whole, and notably, the Antrim County prosecution, which resulted in essentially what could be looked at as jury nullification, really by the jury under certain circumstances. But this is a hot topic. This is something that someone might want to do a deep dive on, might want to write a book about it. But to understand
Right,
the
what you're
entire
saying,
case.
all you need to do is get a copy of the court file, and the complaint's going to have the gentleman or lady's address. So why, if the purpose of FOIA is for the public to be able to understand examine and critique, if you will, the workings of those who work for them, the government. How does disclosing addresses of non-governmental agents that were displayed for a moment, not made part of the court file from that display of the exhibit, how does that advance the purpose of FOIA?
I have to respectfully, I understand that I have to respectfully disagree with the characterization that they're not part of the court file. I know they're not physically in the court file, but they are the exhibits that become part of that appellate record. So the form in which they were introduced, those are the exhibits that are part of the record. And whether or not they're, maintained.
They gave you the exhibits, but they deleted address, date of birth, and Facebook number, whatever that is.
And I'll address that as well, Your Honor.
I'm not laughing because I think anything in this case is funny. I'm laughing at myself, at my own incapacity to understand technology. So, and Facebook, I understand, is old technology. So.
The reason I'm really zeroing in on why I think these addresses have to be looked a little bit differently is really when we look at this exemption in light of the public domain doctrine. Because when we look at prison legal news, if you look at the court's holding, it really kind of split the baby, for lack of a better phrase, and it said, well, there are certain privacy interests that we can still protect here and those were to deal with the more gruesome pictures that were involved, that they said, hey, the way this was done can still be talked about. Certain aspects of this is sufficiently documented that there's no longer any purpose in preserving this exemption. However, there are other aspects of it that we can still protect the family's privacy interests. What I'm saying is with these addresses, the way that they were conveyed in open court, the way that they were made available to anybody, the way that these addresses are now contained in the criminal complaints associated with the cases, that the majority of them specifically with regard to those who were convicted are now available on other governmental sites. This is not the same as a person putting their information in a phone book and then deciding not to share it with a passerby on the street, as the Michigan Federation of Teachers, the example that they set forth. This is different. There's no purpose in them withholding these addresses, specifically the home addresses, any longer for example, Joe Morrison. I would also note, and I don't know if the court staff, I'm sure that they saw it if they did a deep dive, in the documents that the government filed, and I can give you specific page numbers, 300, the Bates stamp, Vandussen 300 to 301, is an unredacted version of what's also Bates stamps as 302 to 303 that contains everyone's phone numbers, everyone's addresses. On the Bates stamp 056, or excuse me, on Bates stamps 054, 055, as part of a certified record of conviction that has a birth date that's redacted for Joseph Morrison. On 056 to 066, that same date of birth is not redacted, and his address is in there. So if it wasn't already out there when it was introduced in the court during the trial, it's out there now because it's currently in the court's file, because it was filed by the Attorney General in this case. The cat is out of the bag. You can't close the door once the walls are caved in. And that's really the argument when it comes to this. I understand the argument that in general, we do have a privacy right when it comes to our addresses. But in this case, with this class of individuals, with these exhibits, the way they were treated in open court and the way they've subsequently been.
Is there any case law that supports the proposition that a person charged with and convicted of criminal activities, information of a personal nature should be weighed differently than a person who has not been charged and convicted?
No, Your Honor, there's not. And I'm a criminal defense attorney. I don't like where this is going, but I'm saying the way the government has handled it renders their claimed exemption meaningless. And the way that the information has been presented and the way that it's widely available because of the public domain doctrine, it's not minimizing the privacy interest. It's really looking at it in a broader scope and saying there's no purpose of enforcing the exemption when it comes to these addresses at this point.
Is the remedy get the legislature to strike this or to amend it?
I'm sorry, I don't know if I
So-
understand the court's
Well, the
question.
legislature said to the public body, a public body may exempt from disclosure as a public record under this act any of the following: information of personal nature, if public disclosure of the information would constitute a clearly unwarranted invasion of an individual's privacy. Okay? And we have this one case that says home addresses. You're saying home addresses are not that type of information in this case because the government has other parts of the criminal court file that his address is listed, and B, he's a convicted felon. And what I'm asking is, and you've indicated, there's no case law which suggests it should be different. And what I'm asking is, if you think the exemption shouldn't apply to individuals who've been convicted of criminal activity, isn't that something the legislature should be deciding? And they can carve out another basis upon which they can instruct the courts. This is it's a statutorily created access.
I understand the court's question. I believe that, my position would be that it's taking a broader position than what I'm arguing. I'm arguing that in this specific instance, it is not a clearly unwarranted invasion of the privacy of the individuals, particularly in this case, because the exhibits were displayed in open court.
Mhm.
And then additionally, because they're also available in other places at this time. So it's not just that, it's
So
not a
it's-
categorical applying to convicted felons or any particular class of people. It's these specific individuals, because again, I think Michigan Federation of Teachers, reading it closely, it sounds categorical, but really the holding is specific to the employees and the reason why they were getting it. Because if you look at the second prong, this is not the same tenuous approach to it, because again, we're talking about what information was available when the prosecution was going on. We're not just saying, hey, just give me a list of all the people that work for you and their addresses, because that's just random, and so to me it's far more specific. Moving on, Your Honor, to the Facebook IDs. I think here I can speak in categorical terms. There's no information of a private nature contained in the Facebook IDs. They simply do not fall into the category that's contemplated by Michigan Federation of Teachers. It doesn't have the same intimate, embarrassing, confidential nature that a person's home address does, or a person's.
Okay, let's say I'm the person who was charged, convicted, I'm serving my sentence, my appellate rates are exhausted, and there was some visual depiction which is presented to the petite jury and to the trial court that's not made a part of the court file for the reasons we've talked about, and it included my date of birth and my home address. Okay, let's assume that's the case, and it has a Facebook ID. What is that? Somebody having that Facebook ID, what do they get to know about me that they wouldn't otherwise know? What do you do with it? If a Facebook ID is a tool, a person seeking information, what do you do with that tool?
You could search for the account.
And then what do you find?
Well, presumably the post that the individual has made, if they're public. But again, I guess I don't know that I don't think we need to get there, because this information doesn't satisfy the first prong of the test. So whether or not it's helpful or sheds light on governmental intricate workings of the government, or it's irrelevant because it's not information of a personal nature. So the court doesn't have to engage in the balancing test when it comes to the Facebook ID.
Why do you think it's not, if my Facebook ID number, now that I've been charged, convicted, tried, and I'm serving my sentence, let's say my Facebook ID number is 12345. You go to Facebook, or anybody else who gets this information goes to Facebook, they type in 12345. And it's going to bring up Jim Redford. It'll bring up whatever, pictures of my dog, the fish I caught, the deer that I was successful hunting, whatever. And then whatever things I've said, or what do you see?
My understanding is it would bring up the exact same information that searching with your name would be on the platform.
So why, okay, if that's the case, then why do you even need the Facebook ID number?
I don't have an answer for the court because I don't think that's the proper inquiry because it's not information of a personal
Well, it's
nature.
the inquiry I'm making.
And I understand. I would say because it's the complete exhibit that was introduced at trial. And I think that's again, a different analysis. Something
Now,
else that the
okay.
court, if I can touch on, since we are kind of touching on the public domain thing. Stevens versus Department of Justice is a case that I just came across. It's 26 Federal 3rd 59, and at page 70, it specifically talks about the test that's kind of.
What year? What year and what circuit?
It's the District of Columbia, Your Honor. Yeah. 2014, Your Honor. I'm sorry.
Thank you. Who's the, Stevens v. who?
Department of Justice.
Okay.
It talks about the test was required for the public domain and talks about the plaintiff having the initial burden or the proponent having the initial burden of pointing to the exact identical record and the identical information.
The proponent of the exemption.
Of the public, showing that the information is in the public domain to override the exemption.
Okay.
The supplemental affidavit that the court has conditionally admitted shows specifically an exhibit, as well as the plaintiff's initial affidavit at page 12, which shows a contrast between what was displayed in open court and what he was able to capture, and then what was provided. And I just want to point that out because, again, it's his burden to show that the identical information was already set forth in the public domain. And so he has been able to capture the exhibits. Now I would submit that that's not the same thing as getting the record, but it was the actual information that he is seeking being shown. And there's screenshots that the court can look to ensure that prong of his argument is satisfied. But I would, to circle back to the Facebook, it's the government's, excuse me, I keep saying the government because I'm used to saying that, the Attorney General's burden to show that the Facebook IDs fall clearly within that exemption. And there is no case law to support that position. There's no, and really doing a deep dive on the basis, the underpinnings of Michigan Federation Teachers, Facebook IDs, they don't meet the same standard when it comes to information of a personal nature. There is one other exhibit that is as pertaining to count one that is redacted, and what's not clear from Ms. Hageman Clark's declaration is whether or not that exhibit was redacted when it was displayed in open court, and that's the military service record. It's Vandussen 399, the Bates stamp, which it's both in the plaintiff's affidavit as well as in what was filed in, I think, Exhibit A, Part 2 to defendant's reply brief. There's numerous redactions on there, including the name of Dan Chappell, who was who was named during the trial, who was the confidential informant before the trial. I'm not clear on that. I would argue that if it was presented in an unredacted format in court, because it's his name and because that information is no longer confidential, that's an improper redaction, and that additionally the court should compel it to be produced in its unredacted format. But unfortunately, I don't know because I haven't had the opportunity to speak with Ms. Hageman Clark or
What exhibit are you talking about? What document?
it is labeled as Vandussen 399. It is I believe it's like a commendation. It's also on page 19 of the plaintiff's affidavit. It is a certificate of release or discharge from active duty.
Also, do you mind if, Mr. DeBear, do you mind if council gives me a copy of that just so I can look at it right now? And you take a look at it first.
Yeah, no objection.
Let me see it, please.
May I approach, Your Honor?
Yes, please do. Thank you. Yeah, this is called a DD 214. Department of Defense Form 214. So gives the history of the service member. Okay, so what's the what's your point, I guess?
Mr. Van Dusen has
Respectfully.
alleged in paragraph 63 of his affidavit that redaction is something that occurred subsequent to it being displayed in court. And because it redacts his name, it's simply not, names unless there's extenuating circumstances or not considered information of a personal nature. It's not justified by the exemptions.
Who offered this? I assume the defense, right? This is an exhibit at trial?
This is an exhibit at trial. I believe it's admitted by the government,
Prosecution.
by the Attorney General. And again, it's the last page of the production as pertains to count one that's also been provided to the court.
All right, and this was produced pursuant to the FOIA request, is that right?
Correct.
Excuse me a second, I've got. Okay, so Mr. Van Dusen, in this case, the one we have the two FOIA requests for, the October and December, is it 2022 requests?
Correct, Your Honor.
Okay, so this is related to the October.
October
22?
13th, 2022 request.
And you believe that okay, and it's your position that they shouldn't, if that when produced at trial it wasn't redacted as relates to the name and
Probably the signature,
the mailing address. Should, oh, signature, remember being separated, yeah. Every service member who's ever been in the armed forces of the United States since certainly the 1970s has one of these. Some of us have more than one.
and Your Honor, notwithstanding the court's position and ultimate ruling on the issue of the address and dates of birth, I still believe that were to take the government's position or the Attorney General's position regarding those pieces of information, that does not
Should have still
cover.
had his name on it.
Yeah, that's correct, Your Honor.
Okay.
If that's if it was produced in that manner at trial, which is
Right.
what's claimed but in the affidavit, which Ms. Hageman Clark is silent on.
Okay. Thank you.
Thank you,
The
Your Honor.
record should, let me just describe it for the record. The record should reflect, I'm looking at what council's described as some document at page 399 of the production. It is captioned certificate of release or discharge from active duty. It does not have the name or social security, the name and social security number, date of birth, home of record, and mailing address and signature are made such that you cannot read them. It pertains to a person who was purported to have been it appears to be what the court knows to be, although the bottom section of this is not copied. It's a form DD 214, which is a discharge certificate from the military service of the United States of America. Shows where he entered service, when he entered service, where his last station was, and where he was released from service, the command to which he was transferred, which is a detachment of a MP battalion, says what his SGLI coverage, which is Servicemen's Group Life Insurance. It tells what his primary specialties are, as well as the record of and dates of service. Block 13 provides his decorations, medals, badges, citations, campaign ribbons, and awards. 14 is military education. Whether or not he participated in the post-Vietnam era GI Bill program, this individual did. And then he's got how many days of leave he's going to be selling back to the service, to the government. Then there's, in the remarks section, I can't read it all, but just for purposes of appellate review, if any of my colleagues on the Court of Appeals, that's what I'm looking at when I'm having this discussion with counsel. It says release from active duty, separation authority, Army Regulation 63, it says AR 635 TAC 200 Chapter 4, which is Army Regulation 635-200 Chapter 4. And he is honorable discharge, the reentry code 1. Completion of required active service, narrative reason. Okay, thank you.
Thank you, Your Honor, and just.
Yep.
Just, if I didn't say it, it can be found on page 19 of the plaintiff's initial affidavit, as well as.
Thank you. I saw the 19 and I just couldn't, I appreciate that clarification.
And it's 399 in part B or exhibit A, part 2 to the defendant's reply brief to the motion for summary disposition.
So and as I understand it, your position is without regard to whether or not social security numbers should have been, let's assume it was presented to the petite jury with no redactions, that even if the court were to conclude some of the redactions were appropriate, they shouldn't have redacted the name, shouldn't have blocked out the name.
That's correct, Your Honor.
Okay,
Thank you.
thank you.
And the way the court asked me to begin, I sort of dove into it, but I got to step back for a second, Your Honor, and just highlight, in the 1/20/25 affidavit that we've provided with the court and to opposing counsel today of Eric L. Vandussen, footnote number 2 is a link to the initial production that was provided by the government to Mr. Vandussen on November 21st, 2022, in response to his October 13th, 2022 FOIA request as pertains to count 1. The reason that was submitted to the court at this point, so you can see it, is because the defendant in the reply brief provided the subsequent production of what was produced on November 8th of 2023. November 8th of 2023, which is after the conclusion of the Antrim County trials as he set forth. And as the court has had some colloquy with opposing counsel in regard to the sort of the affirmative defense of saying, hey, we're going to do something, we're going to look for this stuff, and we're going to get you more later, paragraph 14. And this may occur after the occurrence of certain events, which may be like the Antrim County trial. For example, that's verbatim in what was provided in the answer to the defendant's complaint or the plaintiff's complaint. Just so the court can see, this is the redacted version of what's been marked as Vandussen's 2 that was provided on November 21st versus what was provided on November 8th of 2023, nearly a year later. And that is the pictures of individuals. And again, this can be found in Exhibit A, Part 1 of the defendant's reply brief, Vandussen 002.
Was the trial completed when, and the record should indicate trial counsel is holding up 2 documents. They both have sort of charts, if you, not charts, but a series of images. In one, all the images are blocked out or blacked out, so you can't see anything, who it is. In the second, it's most are photographs or some type of copy of photographs. The one that has all the photographs blocked out, okay? When was that produced?
On November 21st, 2022.
Okay, and at that point in time, was the trial yet completed or?
It was not.
Okay,
The Antrim County trial was not completed.
had that been displayed in open court at any time?
It had been displayed in open court in the Jackson County trial. Because that's what the October 13th request is pertaining to, the exhibits from the Jackson County trial.
Okay,
So after the conclusion of the Jackson County trial, it was produced in the completely redacted form, which again, for the court's review can be found in footnote 2 to the January 20th, 2025 affidavit of Eric L. Vandussen. It wasn't until nearly a year later that the government produced the unredacted version of that document. And I just want to show
in
that
proximity to when that second case was completed and sentenced, when was that done?
the second case was, the verdict was rendered on September 16th of 2023.
When was
And it was-
sentence imposed?
There was no sentence because they were acquitted.
When was the time period from which appeals of rights could be made by non-prevailing parties? 42 days?
Correct.
It was produced. Verdict was when?
September 16th, 2023.
And then it was produced on when?
November 8th, 2023.
Was there anything that the people had a right to appeal
I don't believe so. It was an acquittal.
Not guilty?
And I bring this up, Your Honor, because we're getting, it's certainly my fault, but we're getting very myopic, but in the big picture here, it's obvious that as to count one, the plaintiff has prevailed. Because
What, sorry?
as to count one, the plaintiff has clearly prevailed in this lawsuit. When we look at,
Well,
there's still issues that are unresolved, but
I would categorize that as an argument as rather than as a fact. So you argue that he has clearly failed, and I respect that. But whether he has or he has not will be determined at some point after I have an opportunity to review all the pleadings, including the ones given to me today. So,
that's correct, Your Honor, and I apologize for if I said that
no, it's not. He has not clearly prevailed because the court has not issued an opinion in order. So, and anyway, go ahead, please.
the government has provided no justifiable exemptions for redacting those photographs. And more importantly, when you look at the other issues that the plaintiff is pursuing with regard to arbitrary and capriciousness and intentionally and willfully delaying the production of these documents, the Attorney General had no lawful basis to withhold, leaving aside the issue of the dates of birth and addresses. Even if the court were to agree with the Attorney General's position, the other information that was subsequently produced, the Attorney General intentionally and willfully withheld it from Mr. Vandussen for more than a year after his request. But until the things that the Attorney General wanted to have happen were already completed, which that's not the way that the Freedom of Information Act works. And so the Attorney General has done nothing to answer to that, to the plaintiff's claims with regard to intentional and willful delay. And then that's, again, moving back to the protective order issue. I know everything is sort of, I guess we're looking at everything at one time here, but that's what needs additional exploration here. That's why, in this case, this is an extraordinary Freedom of Information Act case that requires the deposition of the person that was overseeing the production of these documents. Because why is the Attorney General entitled to withhold this information for more than a year before producing it, when there's no basis for the exemptions? If the exemptions were dates of birth, home addresses, that those exemptions could have been claimed, and that and the other information that was clearly non-exempt could have been produced long before the trial was complete, because it had no bearing on the trial.
What other examples of supplemental production do you believe exist in this case which support your position?
I believe the entirety of the supplemental production as to count one versus compared to the initial production support my position. When the court looks at it, you'll see how heavily redacted the initial productions were, and how they are far in excess of the scope of the dates of birth and addresses that we're talking about today. Moving to count two, Your Honor. There is certainly information that may or may not be protected by the work product exemption. There's certainly information that may be frank communications. There's certainly information that may be
Those
delivered.
215 entries, please point to the one that you think you should be entitled to discovery.
Thank you, Your Honor. I would note that I had a difficult time comparing this log to the way that documents were produced. It took us a long time to figure that out. But when the court looks at, for example, document number 1, which is the PowerPoint that is addressed, it was included, I believe, in Exhibit C to the defendant's reply brief. So the court actually does have it in the court file. The height and weight of Justin Watkins is redacted. The government or the Attorney General has provided no support for redacting this individual's height and weight. and I know this seems nitpicky, but it's part of a bigger picture, Your Honor. In the search warrant, affidavit for search warrant, which is, I believe it's document 8. There are names contained in there, and this was also raised in the plaintiff's affidavit. There's the name of the owner of a residence that one of the members of the base went to in error. That's redacted there multiple times. The same information has been published on the Attorney General's press form that's cited to in the plaintiff's complaint. But again, the names, it's all that's to say is the Attorney General isn't really interested in protecting these names because they've used it for their own purposes in the public. When we look at document number 9, which is an email, and this is also can be found in the I believe it's in Exhibit B. I'm not sure if it's part 1 or part 2 of the reply brief, but this is what it says. In addition to the communication, this evidence that was discussed in this email includes a handwritten will, a letter to family, and the transcription of a phone call. In addition to the communication being protected under the work product doctrine, the FBI's description of the evidence collected as a result of the search warrant constitutes information of a personal nature, i.e. letters to family and a handwritten will that, if disclosed, would result in an unwarranted invasion of privacy. The Attorney General has provided no support for that position with regards to the content of the letter.
You're suggesting that you think an email that has contents of a holographic will I mean, okay, what else?
And I would also note to the court that same letter, there's a picture of that letter that was filed in a sentencing memorandum by the Attorney General in Mr. Webb's case. It's a letter written by Tristan Webb to his dad and brother, and a picture of the letter was filed in an unredacted format in the sentencing memorandum for Tristan Webb. And that same sentencing memorandum was provided to Mr. Vandussen in the production in this case. If it's information of a personal nature that constitutes a clear unwarranted invasion of privacy to produce, why is it being produced in one document and being redacted in the other document? That's the bigger issue. But I also would submit that we're talking about addresses, we're talking about dates of birth. We've heard no argument about case law about that a letter, because if a personal letter has some additional protections that, information about a person who is trying to start a race war, who has, all sorts of Nazi paraphernalia at their home. If that information isn't embarrassing or intimate, then why is this letter more embarrassing or intimate? And I think that's left to, I guess, to guesswork, Your Honor, because the affidavit is simply silent on that. I'd also note that in the affidavit, and as well as in the sentencing memorandum, that was provided, Mr. Webb's brother's name and his mother's name, first names were redacted. The exemption log, as far as I can tell, is silent on why those redactions were made. Ms. Hageman Clark's declaration is silent as to why those are made. And again, we're hearing the entirety of the government's motion for summary disposition is pertaining to these addresses and dates of birth and other personal identifying information, not names. Names are not information of a personal nature. So those are also redactions that simply are unlawful in this context. And specifically, so the court knows this is you can find these in the government's sorry, the Attorney General's reply brief, Exhibit B, Part 1.
Okay, where we're at is I've asked you as relates to the attachment 1 exemption log. I want to know the examples that you believe support your position. You have provided me 3. In the remaining 215 entries, are there any other examples?
The information that I'm discussing, the problem is I don't know, it's not mentioned in the exemption log, so I don't know how to direct the court to what the exemption that's claimed for those redactions. I don't know why, I don't know why.
The answer is there are no other examples that you are prepared to give me right now. And the reason for that is you don't think you have enough information. Is that a fair statement? Because I don't understand your position, I guess. Because when I read the exemption log and I see things like investigative summary by a different law enforcement agency, when I see search warrant and affidavit approval for investigation, and that's what the email's about and the purpose of it, and I see lots of entries about discussions by lawyers with their fellow lawyers or discussions or descriptions of their work product, I don't see how someone is entitled to receive the work product or communication of an attorney. And I've been a lawyer 40 years now, this year. The privilege of attorney-client communication is perhaps, other than priest penitent, the oldest privilege recognized in the common law. And that's why I'm trying to figure out what it is you think Mr. Vandussen was not provided in the 215 examples set forth by the respondents. Well, I'm sorry. Yeah, they are the defendants, respondents. And I'm not trying to be difficult or discourteous, but I don't. So I understand the 3 things you've talked about, and I'm trying to drill down to, are there others?
Document number 8, Your Honor.
Yep, you already said that and I already acknowledged it.
Okay, and this,
1, 8, and 9. What else?
one moment, Your Honor.
Okay. While you're, I'm going to give you a minute. I'm going to take a look. One of our other lawyers has been watching online, and want to see if I've got any emails.
Okay.
Thank
Thank you, Your Honor.
So one thing I did have pointed out to me is that in Otis, the only address which is listed is the address of the confinement facility that the individual finds himself in, not the home residence. I don't think it's it's neither, I mean, it's not dispositive to, the issues that we have to decide, but, or discuss, but I would just share that with you. That was shared with me. I didn't find that out on my own.
And Your Honor, I'm sorry, I did get confused and flustered, but I just want to point out that
No,
the
you're doing
information.
fine. There's a lot of papers in front of all 3 of us today. So you don't have to apologize for anything.
The information I was referring to regarding the names of Mr. Webb's mother, there's online monikers belonging to other people that aren't Facebook IDs, but just handles for Instagram and Facebook account that are redacted. Mr. Webb's brother's name, his Google account, that's all pertaining to document number 8. So
Right.
just so the court knows.
Thank you.
There are several entries here that pertain to a meeting, and this is just one example, but that pertain to the attempts to set up a meeting between Mr. Webb's father and the Attorney General herself.
Okay.
For example, document 110, there is, as well as and I would note for document 110, the Attorney General's email address is redacted there. And it's redacted anytime that she is either emailed, that an email is sent to her or she sends an email. No other email addresses from any of the other Attorney Generals are redacted. And I don't see anywhere in here where there's an indication why those redactions are made. As pertains to, for examples, document 110 or document 82, document 83, and any email communication from the Attorney General, her email address is redacted. And
So what?
the burden is on
What, how does, whether or not a specific email address, I don't understand why the email address of a person who's receiving legal advice to fulfill their constitutional and statutory duties
I understand that it seems petty, Your Honor, but the point is there's been no position advanced regarding that redaction. And so that's the thing. There's all these redactions that are left
It's entirely possible
untreated.
they could have redacted the entirety of it and not told you any of it and said, this is attorney-client privilege. This is attorney work product. But they gave you a whole bunch of stuff, but redacted one person's email address.
They gave Mr. Vandussen a whole bunch of stuff more than a year for count 1, more than a year after his initial request, and after he filed the lawsuit, and for count 2, more than a year after he filed the lawsuit. They didn't provide him the initial disclosure, Your Honor, of that's really of any sort of voluminous documents for count 2 was on May 5th of 2023. That's almost 6 months after his request.
But they responded, right? In a timely fashion.
I don't believe it was, they did respond in a timely fashion and said, hey, we will get this done by December of 2022. That didn't happen. There was radio silence until he was provided with the documents on May 5th of 2023 with the 10-page protective log. He filed lawsuit. They said, hey, we'll get you more stuff. Then they got him the stuff they didn't produce anything until after because the case was ticking, time was ticking. Actually, in fact, the discovery period nearly elapsed to the point where we had to extend it. He sought to depose Ms. Hageman Clark at that time. Pursuant to that, discussions were made. Then the subsequent production occurs at the end of December of 2023 with the 40-page production with 817 pages. That's not timely. That's not, these matters are to be dealt with expediently. And so all throughout this case, there's been these.
Does it matter if the requester is asking for things that are privileged, that are completely related to attorney-client communications, and ask for lots of those things, and thereby maybe slows down the process? Is that something that the court should take into consideration at all?
Perhaps, but I don't know how long can they slow down the process? And
I don't know either, but if you have to go back and look at every single document that you provided to in a advisory capacity to a decision maker or in a work product capacity, I'm a firm believer in FOIA. I mean, don't get me wrong, open government, there's nothing like sunshine, nothing like sunshine. But there are also obligations of officers of the court who provide counsel and advice, just like as you said, you're a defense counsel. No one would ever think of asking you for documents that you communicated with your client about. No one. But this is being asked for at great length. And I get that as a governmental agent, there's differences, very different. Having been in, like I said, having received advice and having given advice as a governmental attorney. All right, please continue.
the reason I bring up the difference between the disclosures and the time period is again, to circle back to the position that regardless of what the court finds with pertaining to these very myopic, very specific arguments that are being made today for the addresses, perhaps, one, I would submit that we don't have enough information. And then really, if the court's going to make a determination as to the work product, because of all of the things that have occurred, because of the redactions, for example, in count one, as they were initially, redacting pictures and all these things without any justification, with redacting names and not establishing them in the documents that have set forth, you can't take the Attorney General in this case at their word based on the affidavit that was provided, or the declaration that was provided by Hageman Clark. I also note it's not a notarized declaration. So there's really, it says it's sworn, but it's a defective affidavit for purposes of a summary disposition. So, I mean, there's an argument that the court can't even consider it, but I think.
Did you make that, since it's been before the court for many months, did you file a motion to strike that?
I did not realize it until I was preparing for it this weekend. And that's all I can say about that, but that's the truth. But that, whether the court considers it or not, we need more information, specifically as to the arbitrary and capriciousness and the intentional and willful delay that occurred in this case, as to the punitive damages, because it may be that they can make the argument. I'm sorry, Your Honor, I didn't mean to cut you off.
No, go ahead.
It may be that the argument can be made that hey, this took us all this time to do it. We were working around the clock to do it because we couldn't get it done any faster because of everything you requested. Or it could be that they strategically waited till the trial was over, until it was convenient to disclose the records. And that's not appropriate under FOIA. That's not what's permitted. That's intentionally and willfully exempting or withholding non-exempt material. And so based on all that, I don't believe the court can take anything that the Attorney General has put forth with regard to the other exemptions at its word without doing an in-camera review of those portions of the record. I recognize there's some things legally the court can rule on without doing the review as to the dates of birth, et cetera. But for the more in-depth things, I don't think that the court at this point has enough information to rule. And I think the plaintiff is entitled to conclude discovery with this deposition so we can get those answers.
All right. What else?
One moment, Your Honor, and then I'll finish up. I'll just close with this, Your Honor, and then as the court has already heard me say, the defendant has conceded, and it's on page 4 of their reply brief, that they do not dispute that the supplemental production of records would not have occurred without the filing of plaintiff's lawsuit, or that a requesting person prevails when his or her complaint has a causative effect on the delivery of the information. Leaving aside the issue of the attorney's fees for another day, the defendant is conceding that the filing of the plaintiff's lawsuit had a causative effect on the production of supplemental records as to count 1 and count 2, and factually it did. So if nothing else, if the court were to rule in summary disposition, it would have to be in the plaintiff's favor.
Let me give me just a moment before you return to council table. Right, thank you,
Thank you, Your Honor.
Mr. DeBear.
I'll try to keep this brief, Your Honor. The primary objection I have with counsel's arguments regarding information that was presented in one way in a certain format and in response to the FOIA in a different format. The long and short of what I can take from the argument is that they have these records, the trial records. They have the search warrant and affidavit from press releases. They have all these records. So we're spending a lot of time arguing about exemptions over information that they have.
Well, I think part of, okay. I hear you on that. But I think one of the things that counsel is suggesting is that, Judge, I've given you 4 examples where they withheld this and then 4 others where they gave it to us. So if that's the case, then it's not appropriate for them to rely on 152431A because they've already disclosed it. And I think the other argument that they're making is, Judge, they displayed it in open court. They don't get to say 2431A anymore. I think those are sort of the 2 themes that I hear interwoven throughout both the written submissions and counsel's colloquy with the court today.
And Michigan Federation of Teachers forecloses their argument of saying it was displayed in open court, so we don't get to rely on that. That argument is squarely rejected by Michigan Federation of Teachers. The other
You
argument,
do understand he disagrees with you on your interpretation of the holding of the court of that case.
if, and I didn't bring it up with me, but it's pretty squarely written in black and white. And so there's not much guesswork left after that portion of the opinion is what I'll submit. I'll also note that there's only 2 parts of the test for 15243-1A. Information of a personal nature. Yes, for all the categories. If disclosed, would it constitute a clearly unwarranted invasion of privacy? Yes, because it sheds no light whatsoever on the inner workings of government. With respect to the Facebook,
But it's not, I don't think it's as narrow as that. It's yes, the underlying rationale for why we have FOIA is in order to allow individuals and organizations to obtain information which will be helpful to the person's understanding or entity's understanding of the workings of government. But we also have the statutory construct that the legislature chose to promulgate. And in 2431A, it is, is it personal in nature and is it a clearly unwarranted invasion?
and the Supreme Court has said that that information is information of a personal nature, not only in Michigan Federation of Teachers, but in every FOIA case interpreting MCL 15243-1A,
But it
including
hasn't found that names are, right?
not names, but the only names that we redacted were the ones that were just referenced, brothers of convicted, and that wasn't even in the trial exhibit case, by the way. That was in Vandussen 2B, information that was not introduced into the court of the, into open court. That was squarely, that information would squarely fall within the Rataj versus City of Romulus case. It was also referenced in the ESPN versus Michigan State University case. The fact of being associated with criminal activity is information of a personal nature. And again, the courts have referenced for the only consideration whatsoever for the trial court to consider and for the public body to consider in weighing the balancing test is to what extent would the information shed light on the inner workings of government? That's the only consideration that we need to be concerned with. And the names, or sorry, the addresses, home phone numbers, all of that has already been addressed by case law. The Facebook, the only thing I wanted to add versus you asked a question about name versus account number, or maybe that, opposing counsel did.
Because I don't know anything about it.
You could
so.
type my name into Facebook and find a Facebook profile, I believe is private, but I could also say perhaps I'm a teacher, don't want my students looking me up and I'm my first name and middle name. You would need the Facebook ID to find me. If you're searching my name, you're not going to find it, but you would need the Facebook ID. The department is not undertaking an effort to go and investigate all of these Facebook accounts, just the ID number that leads to their Facebook profile. And I would submit that a Facebook profile where people post such information as jobs, relationships, family, birthdays, that's information of a personal nature under Michigan Federation of Teachers and all the other cases that go on to discuss it. The records that were referenced in which opposing counsel had a problem with in our privilege log for Vandussen 2B, 1, 8, and 9. One was an investigative summary prepared by the FBI, which was produced with limited redactions. So they have a partially redacted copy, plaintiff and his attorney. Document 8, the search warrant and affidavit, was also produced in FOIA with limited redactions to personal privacy. But according to plaintiffs, they already have a copy of it unredacted. So the court
Does
shouldn't
that
even.
matter?
Yes, because
Why?
it can have no causative effect on the delivery of information, this lawsuit, if they already had it. If I want to prevail in a lawsuit, I need to ask for record A, have a public body say, you can't have record A, and then go to the court and say, can I have record A? And the court says, yes, you can. That's prevailing. That triggers the award of attorney's fees. But if you already have it at the beginning, there is no causative effect. And I believe one of the cases that cites the standard is Detroit Free Press versus City of Southfield, a 2005 Court of Appeals case. There has to be a causative effect on the lawsuit with respect to the delivery of information. If you already possess a record, before the lawsuit, there is no causative effect. And that's just sort of basic logic. And then lastly, with respect to not being able to take the department's words with respect to the declarations, Danielle Hageman Clark is a career prosecuting attorney and is currently the bureau chief overseeing all of the criminal prosecutors that we have in the department. Public servants are entitled a deference of good faith, and they're understood to be performing the duties in the manner in which they're held. There has been no untrue statements, and moreover, with the respect that, to take the need to take her deposition. One thing that plaintiffs didn't reference is that there's two other types of discovery generally available in any civil action: interrogatories and requests for production. All this need to explore whether there was, willful obstruction of the FOIA or willful violation of the FOIA. They had the ability to write interrogatories. They had a year, at least a year, since the supplemental production. Nothing happened. There is no need to take the department's bureau chief, who oversees all of the prosecutors in the department, to ask questions which are predominantly going to be related to work product and all of the other prosecutions that here, and questions about, did you intentionally intend to violate Mr. Vandussen's right? I'm going to guess the answer would be no, that the department didn't intend to violate any FOIA rights. The reason for the lengthy delay, if there was one, during litigation and producing the records, I would venture that there are close to 10,000 responsive pages of records, 215 documents in Vandussen 2B, a handful of trial exam documents in the exam of 2A. And it takes time, particularly when you're in litigation, to go through each one of those documents page by page and make a determination of, should we produce this and should we not? That's the reason for the delay. There's no intentional endeavor or mechanism to violate the FOIA in any way. And I would submit that the department has complied with the FOIA, both at the administrative level and then moreover at the litigation level, in attempting to produce as much as we could so as we didn't need to come here for oral arguments or to make this court go through all the 215 records. We produced a voluminous amount of records in an effort to resolve it. There has been no bad faith or ill will. And that's the last thing that I'll end with.
The question. Council shared the photo flow chart.
Correct, which,
And one of them has no images. And then the next one has a bunch of images.
correct. And so, and I believe that was another bullet point that I had missed on my notes here. The one with no images was the initial response to the FOIA request. The one with all the images produced was during litigation. And I would note that one thing that happened in the interim, not necessarily with respect to the trial, but this court's opinion, I believe was dated August 9th or August 11th. And we also had oral arguments and were able to glean the trial court's, Your Honor's, inclinations with respect to the opinion at that point in time. So it wasn't necessarily with respect to the litigation and only the litigation. We had the opportunity to have an order from a court of claims judge saying you're supposed to produce it in the manner that it was admitted in trial court.
Okay, but he says that that didn't come until a year later.
That came pretty quickly. That production was in August of 2023, Vandussen 2A, I believe. It wasn't a year. It might have been several months after. The one that might have been close to a year was
I'm trying to think of how long I've been on this court. I was appointed in May of 2023. So my opinion had to have been obviously after that. And then what your position is that after, within a reasonable time period, after this guy in the Vandussen 1 issued the opinion, then you supplemented.
right. And within the amount of
Got it.
time it took to make sure we were going through and redacting all the phone numbers, because it's not the case that all the documents are searchable PDFs where you can just type in, like, you have to go line by line, page by page and look for the, like, within that amount of time, as Your Honor said, a reasonable amount of time, the production was
Okay.
made. And it took longer in Vandussen 2B because, again, there were so many additional records to review that weren't ever introduced to my, well, perhaps some of them were, but the majority were interdepartmental communications and such like that that weren't introduced in court filings.
All right, we have a second here.
And all I have to say is we'd ask Your Honor to grant the department's motion for summary disposition.
Do you think I have to do an in-camera review?
No, I don't think the court does. It's, the reasons are set forth in our brief, where the declarations and the exemption log leave no further doubt with respect to the applicability of the exemptions. No in-camera review is necessary. If the court wants to do an in-camera review, we will, of course, happily and promptly submit the records for such a review.
All right, thank you. All right, time is 2:55 PM. I'm going to be in recess until 5 minutes after the hour of 3. We'll reconvene then. I do not anticipate we'll be on the record much longer, but I want to talk with one of the lawyers. But we'll be reconvening in 10 minutes. Thank you. Court's in recess.
Your Honor, would you mind if we go back up to the AG's office and have a status conference with Judge Yates via Zoom and then come? I doubt that will take much longer.
When you're done, obviously tell opposing counsel and tell Mr. Kramer, and he'll knock on the door and let me know that you have re-entered the building.
Okay, I'm just upstairs, so great.
If it's, okay, well, Judge, okay, yes, well, I assume you don't have any objection to that. Okay, thank you. Well, yeah, go take care of that. Tell Judge Gates I say hello, and we'll see you in a few minutes. Yeah, thank you. My mind's eye had this for
Yeah, that's November 21st, 2022. Then, quarter, August 20. That's just one where.
the school year to like September 8th, we could have, you know. There's a chance, yes. I had one.
All right, thank you, council. Thank you for being here, Mr. Vandussen. Mr. Cranmer, thank you. And the court staff, thank you. The matter is submitted. We take it under consideration. There's a lot of documents that I gotta look at some more. It is possible you're gonna get an order that's gonna direct you to both council to collaborate on providing documents that I probably already have, but like in a way that I'll tell you how I want it in the order. But I don't know what that is right now. And I'm not one to delay things simply for the purpose of delay. But it's I just there's as we all know in the reply brief of of the defendants, there's 1,000 pages of documents. So there's a lot to look at. The plaintiff has just supplemented the record today. Council has until the time I indicated on Friday of this week to indicate if there are any issues. But I may need some more help. And it'll either be in the form of you might get a call from Mrs. Tomet, my assistant, to have a status conference. So the three of us and the lawyers who are helping me can have a discussion about what I need, as opposed to me issuing an order, which isn't necessarily as clear as I would hope it to be. Because of my fault, not anybody else's, but to try to get us going in the correct direction based on the law of Michigan and the claims that are being made and the defenses being asserted. So that's sort of where I'm at. Scheduling wise, I have another court of claims hearing tomorrow that's scheduled for a few hours. And then 2 weeks from now, I have February case call. And so the other position I have the privilege to serve in here, I've got to be ready for those cases, for those litigants too. So this, I'm gonna work through this as quickly as I can, but I can tell both the state and Mr. Vandussen, you're not gonna have a decision in 2 weeks. You're not, it might be 2 months. And I really wish it could be in 2 weeks, but I just realistically don't see that. I have a number of family obligations between February 10th and March 20th. Each month, each year, we're able to have a time period we don't have cases. March is that month for me, and that's the time I spend time with my family and my children, my grandchildren. So this case is important to me. My wife, my children, and my grandchildren are more important to me. So I hope no one is offended by that, but that's, I've got, time is the one thing all of us have that runs the same way, and I want to spend time with my kids and my grandkids and my spouse. So I'll be working on it. My team's gonna be working on it with me, but it's not gonna happen tomorrow. So I appreciate the advocacy on behalf of both sides of the case in this matter. It's interesting. When I issued the first opinion and that in the matter Mr. Vandussen brought, I never imagined I'd be revisiting these issues again so soon. But as I'm sure none of the lawyers did. So, but again, anyway, thanks for being here. Thanks for traveling here. The weather is tough today, so please be careful as you return to your families and your other places of business and the other places that your schedules will take you. I appreciate very much our court reporter. Thank you, sir, for being with us. Parties have your name, so if they seek a transcript, I'm sure they'll let you know. And if we need a transcript, we'll let you know too. But thanks for being here with us. Are you in the batter's box tomorrow as well, or do we have somebody else that drew the short straw?
I believe you have someone else,
Okay.
unfortunately.
Well, I appreciate very much your helping us, and the court reporters
Yes.
were just really fantastic. So, all right.
Thank
Anything
you.
further from the plaintiffs before we recess for the day?
Thank you.
Thank you. Anything further from defense?
Nothing, Your Honor.
All right. Thank you. All right. The Court of Claims for the state of Michigan is in recess. Thank you. Have a good day. Please go about your business, ladies and gentlemen. Thanks.